Stephanie Lieb, and I am the moderator of this program today. Thank you to the tax law section and the business law section for allowing us to present on the basics of bankruptcy law. This CLE is the second in a 4-part series. The third segment is scheduled for Monday, August 31st, and the topic is tax planning for insolvency and discharge of indebtedness, state and local tax considerations. The fourth segment is scheduled for September 9th. That's the final segment. And the topic is analyzing bankruptcy versus workout options, how to communicate with clients. So please join us for those programs as well. I'm going to tell you what the CLE number is right now. Get a pen. It is 4092. This program has been approved for 1 hour of general CLE credit, but also serves as 1 hour of credit for business litigation certification as well as tax law certification. The format of our program today is going to be a total of approximately 75 minutes. The first hour will be strictly the presentation of the panelists, and we will leave 15 minutes afterwards for questions. Questions will be written into the Q&A section within Zoom, and we'll answer as many of those questions as we can after the 60-minute presentation. But I hope you can all see the Q&A function there. I'll be checking those questions as we go through the program, but we will address them at the end. We will circulate the materials after the seminar to all of the attendees, and we'll also be circulating if 67 slides is just not enough bankruptcy law for you, we'll also be circulating another program that Judge McEwen, one of our bankruptcy judges, provided, and it's a much more in-depth bankruptcy basics document for you. Okay, finally, the format of this Zoom webinar allows you to select speaker view at the top so you can see both the PowerPoint and the screen of the person who's talking. So I recommend that you do that so you can see everything. So let's get started with introductions. Again, my name is Stephanie Lieb. I'm the moderator today. I'm with Trenum Law in Tampa. Trenum is a full-service business law firm serving the Tampa Bay area. Trenum Law may sound familiar to you tax lawyers out there, as my partner, Mike O'Leary, is the current chair of the tax law section. I am a past chair of the Bankruptcy UCC committee, and currently I serve as the legislative vice chair for the business law section. But I am just your moderator today, so let's talk about our panelists. First, we have Chief Judge Carol Delano. She was appointed by the 11th Circuit Court of Appeals as the United States Bankruptcy Judge for the Middle District of Florida in June of 2008. She sits in both Tampa and Fort Myers, and in October of 2019, she was selected by the District Court as the Chief Bankruptcy Judge for the Middle District. One of my favorite things about Judge Delano is how generous she is with her time to the business law section. She currently serves as the judicial chair for our CLE committee. So welcome, Judge. Next on the list is John Hutton. John has spent his entire career as a restructuring advisor and bankruptcy litigator at Greenberg Traudig's Miami office since 1993. He is ranked by Best Lawyers, Chambers and Partners, Florida Super Lawyers, Florida Trend, and he is also board certified in business bankruptcy law. John has a wide range of experience representing debtors, trustees, secured and unsecured creditors, asset purchasers, and even indenture trustees and bondholders across various industries. He is, within the business law section though, he is currently our Bankruptcy Judicial Liaison Committee Chair and has spearheaded this initiative from our section side with the tax law section. So thank you for that, John, and welcome. And last but certainly not least is Andy Layden. Andy is also board certified in business bankruptcy law, and he's an attorney with the Baker Hostetler's Orlando office. bankruptcy being the small world that it is, he also, prior to joining Baker Hostetler, served as a judicial law clerk to Judge Delano. He is ranked in Chambers as a Star Associate. He concentrates his practice on commercial bankruptcy, troubled loan workouts, financial restructuring, and commercial litigation. Andy is actively involved with the business law section and its bankruptcy CC committee. I am personally thankful to Andy for trekking up to Tallahassee at least on one occasion for our committee to testify in our legislative efforts. So thank you for that. He's also the vice chair of the CLE committee. So that is your panel for today. And I think we'll dive right in. Judge, if you'll unmute. Okay, great. And tell us about the Bankruptcy Code.
All right, thank you, Stephanie, and thank you for those introductions. Hopefully, we're going to have an interesting presentation today. There are some of you that are online who are bankruptcy practitioners, and I hope you don't hear anything you don't already know, because this is going to be very, very basic. But our real goal today, particularly for those of you who are tax lawyers or other business law section members, is for you to have a general understanding of what happens in bankruptcy courts so that you can advise your clients what their appropriate action should be, whether they are potentially debtors or whether they are potentially creditors in a bankruptcy case. It's just helpful to know some of the terminology and some of the things that happen in a bankruptcy court. So we're talking primarily, of course, about the Bankruptcy Code, and I'm sure that all you tax lawyers are happy to have an area of law that is code-based. We have the Bankruptcy Code. We also have the Federal Rules of Bankruptcy Procedure to give us guidance. So there's really two goals behind the bankruptcy system, and one is a fresh start for debtors. So your honest debtor should get a fresh start. Debtors often have financial problems for a variety of reasons, many of which are outside their control. And if those debtors were forced to deal with each of their creditors, they might end up in a fetal position in bed, not able to move. And at some points, they have to have some relief. And so that is one of the major goals of the Bankruptcy Code. And the other goal is the fair and equitable treatment of creditors, whether an individual creditor's claim is being treated in a certain fashion, or whether we're looking at the distribution of the debtor's assets to creditors in a case. So next slide, Steph, if you would. And I forgot one point from the prior slide, but don't go back. We talk about the Federal Bankruptcy Code a lot, but we look at state law all the time. Matters of contractual interpretation and parties' individual rights are often determined by state law. So state law is very important, but the Bankruptcy Code itself is applied, across the country. So there are various substantive chapters of the Bankruptcy Code that we're going to be talking about today. Chapter 7 is liquidation. Chapter 9 is for reorganizations for municipalities. We don't deal with Chapter 9 at all in Florida because under Florida law, the governor has to authorize the filing of a Chapter 9 case. But as you all probably know, the city of Detroit filed bankruptcy a few years ago under Chapter 9, but we're not going to be dealing with that today. We're also going to be talking about Chapter 11 reorganizations, including the new Subchapter 5 that's available for small business debtors. Chapter 12 is for family farmers and family fishermen. We'll talk about that a little bit. Chapter 13 is for individuals who have regular income and they have some specific rights under Chapter 13. And then Chapter 15 is recognition of foreign bankruptcy proceedings. That doesn't come up a lot. I think in the Southern District of Florida, it probably comes up a little more often than it does in the Middle District. I've probably in the last 12 years on the bench had maybe 12 or 15 Chapter 15 cases. Essentially, that's where there's a bankruptcy proceeding in another jurisdiction, another country, and then the bankruptcy trustee in that case comes to the United States in order to assert control over assets that the debtor owns in the United States. So that's just a brief overview of the various chapters. Then we have two types of bankruptcy filings, and usually you'll see voluntary petition. You'll see that phrase. So that gives you a heads up that the debtor chose to file bankruptcy. In most of the cases that we see, probably 99.9% are voluntary petitions where the debtor has chosen to file a bankruptcy. There's also involuntary petitions. So an involuntary petition is when a group of creditors get together and they're not happy and the debtor is insolvent and not paying debts as they become due, and the creditors file an involuntary petition. So if the debtor has more than 12 creditors, then 3 creditors have to join together. Their debts cannot be the subject of a bona fide dispute as to liability or amount. So filing an involuntary bankruptcy against a defendant in a lawsuit is like not generally a good strategic move. If the debtor has fewer than 12 creditors, then just 1 creditor can start an involuntary bankruptcy by filing a petition. But there's a real downside here. There's a risk. If it turns out that the court dismisses the involuntary petition because there's a dispute as to the amount of the creditor's debts, or if the involuntary petition was filed in bad faith, then the petitioning creditors can be liable for reasonable attorney's fees and other damages. So I haven't had too many cases where that's happened. I probably have dismissed 2 or 3 involuntary petitions. One that I recently dismissed, I believe I awarded about $250,000 in attorney's fees. It was a pretty big case and a pretty significant dispute. So before you think about filing an involuntary bankruptcy, make sure you're talking to some really experienced bankruptcy lawyers and make sure you have all of your ducks in a row, because there can be some consequences. So what are the reasons for filing a bankruptcy? Steph, if you'll move. Okay, voluntary petitions. They can be filed by either individuals or corporate entities. When we say corporate entities or companies, LLCs, partnerships, they can all file bankruptcy petitions. And some of those reasons are just overall financial distress due to economic conditions. Obviously, right now we're dealing with the COVID-19 pandemic, and that's created a real stress on a lot of businesses. I know in Southwest Florida, we've had many bankruptcies that have been filed as a result of Hurricane Irma and then the red tide, really creating problems for businesses. Sometimes a borrower has a loan that's becoming due, and for whatever reason, the borrower is unable to refinance. So the borrower may choose to file a bankruptcy and gain some time in that process. Sometimes there's a foreclosure that is pending. Bankruptcies are frequently filed on the eve of foreclosure. Creditors tend to be appalled and to think that it's a sign of bad faith when a bankruptcy is filed on the eve of foreclosure. Most bankruptcy judges would tell you, why would you wait? Why would you file before then? There's really no need to until there's some threatened action. If a debtor has a significant judgment against it, it may file for bankruptcy in order to be able to address that judgment in the context of a bankruptcy rather than having assets levied upon or executed. To facilitate a transaction, this is a reason for filing bankruptcy that many people don't even think of. Sometimes a debtor wants to sell property or a business, and because of the claims of creditors, the debtor needs to have and provide the buyer with protections of a bankruptcy court order, that the sale is free and clear of liens and interests, and that's a major reason for filing a bankruptcy. We see a lot of sales in the context of bankruptcies. I recently have had a bankruptcy case that was filed because there were title insurance issues that just could not be resolved absent years of litigation in state court. But in the context of a bankruptcy case, the debtor could file a motion to sell the property free and clear of liens, and the bankruptcy court could authorize that sale. General reorganization is another reason for a business or an individual to want to file a bankruptcy, just the need to restructure debts, whether that's paying secured debts over time or paying unsecured debts either in full or some portion of the unsecured debt over time. Another reason, and that's not on the list that I just wanted to mention as a potential reason for filing a bankruptcy, is the ability of a debtor to reject executory contracts. So for example, if you had a client that had perhaps 10 or 12 business locations, perhaps they were retail stores, perhaps they were long-term leases, and they've realized that 3 or 4 of those locations just start generating money. But if they close those locations and they're on the hook for the balance of the lease, then that's going to create a real financial hardship for the company. So in the Chapter 11 context that we'll talk about in a few moments, the debtor could reject those executory contracts, those leases, and under the Bankruptcy Code, the damages for the lease rejection would be capped at a year's rent. So that's a significant reason for filing a bankruptcy. And when you look at some of the large national chains that have filed bankruptcies over the last 20 or 30 years, Kmart, Sears, sometimes that's what they're trying to accomplish. That's a real reason for filing. Okay, so in the bankruptcy world, we talk about the petition date all the time. And the petition date, I like to call it a line in the sand. So you want to think of the bad stuff all happened pre-petition and the good stuff's all going to happen post-petition. And that line in the sand is very, very important. And almost every bankruptcy case or every bankruptcy court's decision that you'll read, you will see right up front the date of the petition, because that is really the most important date in the history of the case. In the involuntary, the petition date is actually the date that the order for relief was granted, and there's some protections for creditors who are what we call gap creditors during the gap period, and those are creditors whose claims were incurred between the time that the petition was filed and when the order for relief was actually entered. In voluntary cases, you'll see the terms order for relief all the time, and that is really that's really just a synonym for another word for the date of the filing of the petition. Venue is often a consideration. Where should a bankruptcy case be filed? And generally, businesses will file where they are incorporated or where they have their principal place of business. There's rules for individuals and residency requirements, but generally it's where an individual is residing. And but for corporations, we look either at the state of incorporation or where the assets are located. Sometimes there will be some venue selection, forum shopping done, where a subsidiary company will file a bankruptcy case in one jurisdiction, and then lo and behold, the parent ends up filing, and then they tag along where the subsidiary had filed. So we have some very typical venues for large cases. There's a lot of practitioners and probably judges in Florida that are not happy to see many large cases go outside of state. Delaware is many cases are filed in Delaware. That's because Delaware is the state of incorporation for many large businesses. Southern District of New York the same way, and also the Southern District of Texas. Those companies can choose where they want to file bankruptcy. Perhaps their businesses are actually located in other jurisdictions, but they were incorporated in Delaware or the Southern District of New York, and then they choose to file their bankruptcy there.
Judge, didn't Steinmart file its Chapter 11 recently in Florida?
Yes, as it turned out, I did not know that Steinmart's headquarters are in Jacksonville, and Steinmart elected to file its case in our Jacksonville division. Another large case that was in our Jacksonville division, you all may have been familiar with the Winn-Dixie bankruptcy case. Winn-Dixie was originally filed in the Southern District of New York, but creditors lobbied and filed a motion to transfer venue to Jacksonville, and that's where the case ended up. So my colleague, Judge Jerry Funk, has handled both of these large cases. Okay, so who are the players in a bankruptcy case? The entity or the individual who files the bankruptcy is called the debtor, and in bankruptcy court, we don't often refer to the debtor by name. We frequently just say the debtor. So that's the major player in the bankruptcy case. The Office of the United States Trustee is a division of the Department of Justice, and the United States Trustee's Office is charged with supervising generally bankruptcy cases within its jurisdiction, and they participate very heavily in Chapter 11 cases. They also monitor the activities of the Chapter 11 and the Chapter 7 and Chapter 13 trustees. I'll talk about them in a moment. And they keep an eye on Chapter 7s and Chapter 13s as well, but they're most heavily involved in the Chapter 11 arena. Chapter 7 trustees, there's a Chapter 7 trustee appointed to every Chapter 7 case. Those trustees are appointed from an approved panel of trustees that have been vetted by the United States trustee, and they passed a security clearance and they posted a bond. And each case is assigned at random to one of the panel trustees. Creditors can choose to elect a different trustee if they want. They have to go through certain procedures regarding that election, but I would say 99.9% of the time, the Chapter 7 trustee is appointed from the panel. On occasion, there are trustees that are appointed in Chapter 11 cases. Generally, and I'll talk about this more in a moment, a Chapter 11 debtor is a debtor in possession with all the rights and powers of a trustee, and there is no, quote, trustee appointed in a Chapter 11 case, but there are certain cases in which that is appropriate and the court will appoint a trustee. And the United States trustee then selects the Chapter 11 trustee after consultation with the creditors. So the court is not involved in that appointment process at all. In your larger Chapter 11 cases, there are sometimes creditors committees. The debtor's 20 largest unsecured creditors are invited to serve on a creditors committee. That creditors committee is then formed by the United States Trustee's Office, and that creditors committee can retain counsel to represent it at various hearings, and that would be an administrative expense that would be paid through the bankruptcy case itself if there were funds available. Sometimes there are not. And the creditors committee members themselves, however, are not compensated for their service on the committee. Then, of course, we have creditors. We have secured creditors, unsecured creditors, a lessor, a landlord could be an example of a creditor or a party to an executory contract. There are priority creditors, such as the Internal Revenue Service, things along those lines. Many professionals are involved in bankruptcy cases. The debtor is generally represented by counsel. Corporations, obviously, need to be represented by an attorney. Accountants are retained, brokers are retained. Those professionals are all retained by the debtor or by various parties, such as the trustee or the creditors committee. That retention is approved by the bankruptcy court, and the compensation that is paid to those professionals is subject to approval by the bankruptcy court. Equity holders, to the extent that they're shareholders in a company, they're also parties in the bankruptcy case. And then many governmental entities are involved in bankruptcy cases from time to time. If it's a publicly traded company, the SEC is involved, the IRS is frequently involved, many other governmental entities can be involved from time to time. In every bankruptcy case, there is what we call a creditors meeting. So generally 30 to 45 days after the case is filed, a creditors meeting is held. All creditors are given notice. Creditors can attend that creditors meeting. It is presided at, not by a judge, but by the trustee in the case. So if it's a Chapter 7 trustee, the Chapter 7 trustee presides. If it's a Chapter 11 case, then an attorney with the United States Trustee's Office would preside at that creditors meeting. But creditors have the opportunity to ask questions. Sometimes that opportunity is somewhat limited because of time constraints. Creditors who would like to do a more thorough examination are allowed to conduct an examination under Rule 2004 of the Bankruptcy Code. We tend to call that a 2004 exam. I have to tell you, in the year 2004, that was very confusing because when people would talk about a 2004 exam, we didn't know, was it an exam that took place in 2004 or was it an examination under Rule 2004 of the Bankruptcy Rules? So now that we're 2020, it's not quite so confusing. So let me just kind of run through the chapters and briefly tell you what happens. Again, as I mentioned, in a Chapter 7 case, Chapter 7 is liquidation for an individual or a corporate entity. And the Chapter 7 trustee is going to administer non-exempt assets. And I'm going to talk about exemptions a little bit more in a few moments. But the Chapter 7 trustee essentially marshals all of the debtor's assets, liquidates them, ends up with a pot of money, and then distributes them to creditors in their order of priority under the Bankruptcy Code. So number one order of priority is administrative expenses. That would include the trustee's expenses and legal fees, things along those lines. But it goes down in orders of priority. Domestic support obligations are high up there. Tax obligations are high up there. General unsecured creditors get paid last. And if there's any money left over at the end of the day, it goes to equity, or if it's an individual debtor, back to the debtor. And sometimes that does happen. You see the note there that litigation claims are included, and that is correct. So if the debtor was involved in an accident or has a lawsuit against somebody, the trustee essentially steps into the shoes of the debtor and can then litigate that claim on behalf of the debtor. Individual debtors keep exempt property. Again, I'm going to talk about that again in just a few moments. And there are no exemptions, though, for legal entities such as corporations or partnerships. That only applies to individual cases. So the objective, Seth, if you'll change the screen, please. The objective for a Chapter 7 debtor, an individual debtor, is to get a discharge. When a debtor is discharged of debts, the debtor no longer has any personal liability on those debts. So if the debtor had a mortgage on the debtor's home, the debtor's personal liability would be discharged. However, the lien itself would survive the bankruptcy. And the same applies generally to all secured debts like car loans or other secured loans. There are grounds for creditors to object to discharge. So typically it would be an unsecured creditor that would want to object to a debtor's discharge. So a dishonest debtor who has lied under oath or lied on his bankruptcy schedules or lied at the creditor's meeting or has hidden assets is a debtor whose discharge might be barred. That requires filing a complaint against the debtor in the bankruptcy case. Also, creditors can seek to object to the dischargeability of their own individual debt. We call that an exception to discharge. That's not really an objection to discharge. It's an exception to discharge. So there are some types of debts that under the Bankruptcy Code just automatically are not discharged. So most domestic support obligations are not discharged in a bankruptcy case. Most recent taxes are not discharged in a bankruptcy. But there are other types of debts that are going to be discharged in the bankruptcy unless the creditor files a complaint to accept the debt from discharge. So that would be debts that were incurred through the use of fraud or a false financial statement or through embezzlement or larceny or intentional injury to a party. So those types of debts require a specific complaint, and you need to be very in tuned and attuned to the need to file that type of a complaint.
And does the deadline?
So there are.
Sorry, can you go over the deadline on that?
Sure. So the deadline for filing those types of complaints, either an objection to discharge or a complaint to determine the dischargeability of a debt, is set at 60 days after the date first set for the 341 meeting, which is what we call the meeting of creditors, because it's under Section 341 of the Bankruptcy Code. And so that date is calculated for you in the notice of the bankruptcy case that you will receive. So I probably should go back just a moment. When I talked about the creditors meeting and it being set, it's set and it's noticed to all creditors in what used to be called a notice of commencement. And if you talk to a bankruptcy lawyer, they'll talk about a notice of commencement. A few years ago, they decided to change the name of the form, and now it's a notice of Chapter 7 filing or a notice of Chapter 11 filing. But that notice will have a lot of information, including the date of the creditors meeting, the 341 meeting, and it will also have the date by which creditors need to file complaints objecting to discharge or to determine dischargeability of the debt. So that's an important date. If you have a client that receives a notice of a bankruptcy filing, you want to make sure you get that date calendared and you don't miss it. The court can extend that date for cause, but you need to file a motion before the expiration of the deadline. Creditors also need, in Chapter 7 cases, to file proofs of claim, but only in cases where it appears that there are going to be just assets for distribution. So many Chapter 7 cases are what we call no asset cases. There's never going to be any money available for distribution to creditors. And in that case, there's no point in forcing those creditors or asking them to file proofs of claim because it's not going to make any difference anyway. If the case from the get-go looks like there's going to be there are going to be assets available for distribution to creditors, then that notice of filing, the notice that you receive at the beginning of the case, will have a claims bar date in it. More commonly, the trustee files a notice with the court that there are assets available, and the court then sends out a separate notice of the claims bar date. But that is something that you really want to monitor, because if a Chapter 7 creditor doesn't get a proof of claim filed on time, then that creditor is likely not to receive any distribution in the case at all. So that's in a nutshell what happens in a Chapter 13, Chapter 7, and I'll move on to Chapter 13. Chapter 13 used to be called a wage earner plan, and everybody calls it that, but really it's for individuals with regular income. So there are some debt limits in a Chapter 13, and you can see there on the screen. Unsecured debts have to total less than $419,000, and secured debts have to total less than $1,257,850. Why is that important? For a couple of reasons. One is that in Chapter 13, creditors do not get to vote on a Chapter 11 plan, on the Chapter 13 plan, the way they can on a Chapter 11 plan. They're just stuck with the plan as long as the plan satisfies the requirements of the Bankruptcy Code. And some creditors want the ability to reject a plan, and they may be able to prevent a debtor from confirming a plan. So if the debtor, for example, had $2 million in secured debt, and most of that was with one creditor, that creditor might want that debtor to be in a Chapter 11 where the creditor would have more control in the case. Now, that said, most of the judges, as far as I'm aware, and certainly within the Middle District of Florida, don't consider these debt limits to be jurisdictional limits. So if nobody objects to the debtor's eligibility to file a bankruptcy because the debtor's debts exceed the debt limits, the court's likely to let the case proceed under Chapter 13. But if you have a creditor, if you represent a creditor and the creditor has a strong position on this, you want to file a motion to dismiss the case early on, and that'll force the debtor to convert the case to a Chapter 11 if the debtor wants to stay in a bankruptcy. So what happens in a Chapter 13 is that the debtor is required to file a Chapter 13 plan, and all of our districts have a form plan that they're required to use, and the debtor proposes to make monthly payments to the Chapter 13 trustee, and then the Chapter 13 trustee disperses those monthly payments to the creditors according to the terms of the plan. The Chapter 13 trustee receives a percentage of the payments that are coming through the plan. That's how the Chapter 13 trustee is compensated. And the debtor can file a plan of up to 5 years in length, and depending on what the debtor's income level is, the debtor might be required to commit to a 5-year plan. And usually most debtors tend to want to be in a 5-year plan in order to keep their plan payments reasonable. And many of those debtors are filing Chapter 13 plans because they're trying to cure arrearages on their home, for example. And so the longer they can spread those payments out, the more beneficial that it is to them. In Chapter 13, that claims bar date is absolute. So, a Chapter 11 creditor, a creditor in a Chapter 11 case may miss a claims bar date, and there's a Supreme Court case that says, oh, well, if there wasn't any prejudice and it was excusable neglect, that's okay. That analysis does not apply in a Chapter 13 case. So that claims bar date is absolute, and creditors need to file that claim before the claims bar date. The claims bar date will always be listed in the notice that comes out to creditors at the beginning of the case, so you need to keep an eye on that. Why would people file a Chapter 13? What do they want to do? One reason is because they can't pass what we call the means test in a Chapter 7 case. So there were some amendments to the Bankruptcy Code in 2005 that were designed to keep high-income debtors who could afford to pay back their debts from being able to file a Chapter 7 and discharging them. So we have what's called a means test in a Chapter 7 case that disqualifies some individuals from filing a Chapter 7. So if that's the case, they might want to file a Chapter 13 in order to address their debts. They have the ability, as I mentioned before, to cure delinquent mortgage payments over time. I like to explain it like this. So let's say a debtor has been sick for a year or out of work for a year, and their house payments were $1,000 a month, and so they're $12,000 behind, and then they get better, they're going back to work, they can afford to make their house payments again, they call their lender, they say, hey, I can make my house payments, and the lender says, great, send me your certified check for $12,000 plus our attorney's fees, and we'll reinstate your loan. Well, the problem is the debtor doesn't have that $12,000. So the debtor can file a Chapter 13, spread those payments out over time, up to 5 years. And so that really helps debtors to save houses. A debtor can also do what we call strip off a junior unsecured lien. So on a debtor's principal residence, The debtor cannot, under the Bankruptcy Code, modify the terms of the mortgage that's secured by the debtor's principal residence. There's an exception to curing arrearages out during the term of the plan. The debtor can do that, but otherwise the debtor can't modify that loan. Well, then you ask, how could a debtor strip off a junior lien? Well, if the property is totally underwater and the junior lien is totally unsecured, so for example, you have a debtor that owns a house that's worth $150,000 and the first mortgage is $200,000, then the second mortgage is completely underwater. There's no security interest to support the second mortgage's lien, and the debtor can strip off that lien in a Chapter 13 case under 11th Circuit law and in Supreme Court case law. So we don't see those strip-offs quite as frequently as we did after the 2008 recession, but I would say 2010, 2011, 2012, we were stripping off many, many junior liens. And for a while, there was an inconsistency in the 11th Circuit, and liens were being stripped off even in Chapter 7 cases. But that's, the Supreme Court put an end to that, so we don't do that anymore. The debtor in a Chapter 13 plan can also modify the interest rate on a secured loan. The debtor can't modify the interest rate on a loan secured by the debtor's principal residence, but the debtor can modify the interest rate on a car loan or on a loan secured by property that's real property that's not the debtor's principal residence. You're going to hear this expression if you hang out in the bankruptcy courts. TIL. TIL? What is TIL? What is the TIL rate? Well, TIL was a case, T-I-L-L, the name of a case before the Supreme Court that basically establishes standards for setting interest rates in bankruptcy cases. And so the TIL rate is usually prime +2, something along those lines. The other option that a debtor has in a Chapter 13 case is to cure or to pay non-dischargeable claims. So if the debtor is behind on child support, the debtor can pay that through the Chapter 13 case. And the only downside to the debtor is that there's no discharge until after all the plan payments have been completed. Let's see.
Judge, given
Next.
the time, would you mind if we skipped over Chapter 12 and 15 and went straight to 11?
Absolutely. Let's do that.
Do that. There we go.
Yeah. Okay, so Chapter 11, businesses may want to do an orderly liquidation, or they may want to reorganize. As I mentioned earlier, the debtor is a debtor in possession, all the rights and powers of a trustee. So when you're reading the Bankruptcy Code and you read the trustee can do this, the trustee can do that, the trustee has the authority to do something. If it's a Chapter 11 and there's no Chapter 11 trustee, the debtor in possession has all of those rights and powers. The debtor in possession does act in a fiduciary capacity to the debtor's estate. There are grounds for appointing a Chapter 11 trustee. Generally, we're talking about fraud or mismanagement. Creditors can get together, file a motion for the appointment of a trustee. That happens occasionally. Sort of lesser relief is the appointment of an examiner, where no one really has a clear sense of what's been going on with the debtor's business, and someone like a forensic accountant is appointed to examine the debtor's books and records. I would say that probably happens less frequently. Sorry about that. Next slide, Steph, please. Okay, another alternative is for the debtor to retain a chief restructuring officer. Sometimes if you've had a company that perhaps has been mismanaged, but they don't want a bankruptcy trustee appointed, they'll bring in a third party as a chief restructuring officer to kind of head off those arguments at the past. It's really helpful for that person to have restructuring experience, and there are a number of people throughout the state that have a lot of that experience. They do a great job, and then the debtor can avoid all the issues relating to the appointment of a trustee or an examiner. Sometimes there's a conflict of interest between the debtor's principal and the debtor, and that would also assist in that process. And again, I'm going to harp back on this filing a proof of claim issue. In a Chapter 11 case, if a creditor's claim is scheduled as contingent, unliquidated, or disputed, the creditor has to file a proof of claim. Now, if the debtor has correctly scheduled the creditor's claim, in theory, the creditor doesn't need to file a proof of claim. because how often is the creditor going to be going and looking at the debtor's bankruptcy schedules and seeing how the creditor was scheduled? So the best practice is to file that proof of claim. In the state of Florida, we are uniform, and that claims bar date is always in that notice of Chapter 11 filing that you'll receive, so you need to take care of that. Small Business Reorganization Act went into effect in February of this year, and it's supposed to be a simpler process for smaller businesses to file Chapter 11 cases. It's a little more relaxed. Debtors don't have to file what we call a disclosure statement. The plan process is similar. There's no creditors committees, which can save a lot of money. The whole process is a lot easier in terms of getting to confirmation. There is a small business subchapter 5 trustee appointed to every case that is supposed to be a facilitator to facilitate the debtor in working out a consensual plan with creditors. And the other advantage is that the small business debtor in a sub 5 case can pay administrative claims over the life of the plan rather than having to pay them at confirmation. So administrative claims would be things like attorney's fees and things of that nature that the debtor might not have cash on hand to pay right away. So maybe a little tougher for the debtor's professionals. Then, of course, we've had some recent changes with the CARES Act. Chapter 11 primary change is that it increased the eligibility for filing a small business, an SBRA case, up to $7.5 million. In Chapter 7 and Chapter 13, stimulus money isn't included in calculating the debtor's income, so that makes it a little bit easier. And Chapter 13 debtors who already had confirmed plans as of, I think, March 2020, can extend their plan payment out over 7 years instead of 5 years. And this CARES Act provisions are only effective really until March of 2021. And that takes us to creation of the bankruptcy estate, something I just want to talk about quickly. So under Section 541 of the Bankruptcy Code, everything that the debtor owns on the date of the filing of the petition is property of the debtor's bankruptcy estate. Everything, all rights, legal, equitable, whatever, all property of the bankruptcy estate. So if you're talking with a client, let's say you have a high asset client, high net worth client that's having a lot of problems and thinking about filing bankruptcy. And when they hear the thought of filing a bankruptcy and that if they file a Chapter 7, the bankruptcy trustee is going to marshal all their property of the estate, all the assets, and sell it, they're horrified. But part of the fresh start analysis is that it's not a fresh start if a person is stripped of every single thing they belong. And so the debtor is allowed to carve out from property of the estate what we call exempt property. And exemptions are governed in Florida by Florida law, some federal overlay. Tenants by the entirety's property is generally either considered exempt or not property of the estate. And generally you just look to the Florida schedule of property that are exempt from execution by creditors, which kind of meager in Florida. When it comes to personal property, $1,000 in personal property, $1,000 in equity in a car. If you don't have a homestead, an additional $4,000, husband and wife can stack them. But Florida, very liberal, unlimited homestead exemption with few exceptions. There are a few exceptions depending on residency in the state and things of that nature. But unlimited homestead exemption, pensions, retirement plans, annuities, all exempt. So wealthy people generally come out great. Your poorer people sometimes have to buy back some of their assets from the Chapter 7 trustee. So that's basically, I think, what I was going to cover, Stephanie. And if there's any questions you want to ask me now, great. Otherwise, I'm happy to pass the baton.
I think we will hold the questions. Thank you, Judge. As everyone can see, this is a monster of a topic to try to cover in an hour, but Judge, you did a great job. And we'll move on to John to cover the automatic stay.
Thank you, Stephanie. You want to move to the next slide? I'm going to speak now about some of the real benefits of filing bankruptcy. Again, this is part of a series. And I know one of the paradigms is, and the question that a lot of people on this call are considering is a situation where a client has the opportunity to do a workout or file a bankruptcy. Maybe they have a workout arrangement with their primary secured lender, but there are other circumstances that may counsel in favor of a bankruptcy. And one of them is the benefit of the automatic stay. So if there is just a situation with one creditor and you're able to work out with your senior secured lender, that's great. You're able to execute on that outside of bankruptcy. But if you've got a situation, and we're seeing this a lot now with COVID, where so many businesses are shut down or very limited operations, there's little cash flow coming in. So it's not just a question of working out the issues with your senior secured lender, but you've got other vendors that are sending demands, other lawsuits that are getting filed. And this is one of the real benefits of bankruptcy is the automatic stay. Immediately, the automatic stay is just that, it's automatic. Upon the filing of a petition, all collection efforts, all litigation, I say virtually all, that we'll get to some exceptions, but most litigation activities and collection efforts are stayed. It's called the breathing spell, and the whole intent of the automatic stay is give put a pause and allow the debtor a period of time during the bankruptcy. I'm talking primarily about the Chapter 11 paradigm now, to reorganize, restructure its debt, negotiate with creditors, and avoid the race to the courthouse that would otherwise occur outside of bankruptcy. So that's a real strong benefit to the bankruptcy stuff. And if you want to go to the next slide. That being said, there are some situations where creditors can come in and seek relief from the stay. As the judge referred to before, there are some, in a foreclosure context, there are some creditors or banks that might become outraged at the thought that a debtor on the eve of foreclosure could file a bankruptcy proceeding and may want to come in and seek stay relief so they can proceed with the foreclosure. And of course, the effect of that would be catastrophic as far as the bankruptcy is concerned. So it is a tough request to make, especially at the outset of the case. But if it's a litigious case, the creditor may come in, ask for stay relief. They can either do so for cause, and we'll get into what that means, or they can argue that there's no equity in the property and it's not necessary for an effective reorganization. For cause, they generally need to show a lack of adequate protection. The value of the collateral is deteriorating, that the debtor's not maintaining it, and there's a huge hole in the roof, the property's in really bad condition. Whatever the case may be, they need to make a compelling case that they're not being protected, and that the continued operation on automatic stay, preventing them from foreclosing, is causing them real harm. And that can also be shown with waste or mismanagement. The other prong, they need to show lack of equity in the property, and that's not necessary for an effective reorganization. Those are actually two components. A lot of times creditors come in and say, hey, we're underwater, and often there's a dispute about the valuation of the property. So,
John,
sure.
can I ask you a quick question? So say you're preparing for a Chapter 11 case, and you know that this is going to be a litigious situation with the secured creditor. As the debtor, what can you do? You know it's coming at you, or it's going to be coming at you. What can you do to prevent?
It's a good question. There's certain situations where it's potential and you're going to implement transactions that judge referred to earlier. There's other situations where you are filing the eve of foreclosure, the secured creditor is aggressively pursuing the foreclosure of the collateral. Maybe it's a vulture fund that's purchased the debt at a discount and really wants the property. You need to prepare for that. One thing you might want to do, if you believe there is equity in the property, make sure you have an appraisal in hand before you file. Also, you want to have a good story to tell why you're there in the reorganization proceeding, what you're trying to accomplish, what your plan is going forward. You need to show the judge a roadmap as to why this is not just a futile effort. You're not there just to delay or frustrate the rights of the secured creditor, but you have a real reorganization purpose to the proceeding. And if you're able to demonstrate that, you're usually able to get across that, or at least early in the case. As time goes on, you'll have to demonstrate that you're able to implement the things that you've said you're going to implement. But at the outset, you need to be prepared to make that showing. So Stephanie, you can move to the next slide. The stay is serious, and creditors need to be careful about not violating the automatic stay, which could result in sanctions. And one of the golden rules, as highlighted below, is that if there's any doubt as to if you're a creditor and there's any action that you want to take, get a court order. Judges are very comfortable entering those. A lot of times they're known as comfort orders, because sometimes it's not really clear whether it even would be a violation of the stay, but it's better to be safe rather than sorry, and it's better to seek that comfort order. Next slide, Stephanie. This covers some of the exceptions to the automatic stay. As I mentioned before, not everything is stayed. Most collection efforts are, but criminal proceedings are not stayed. There are certain protections of interest in property that are not stayed. We'll cover that a little bit later. Government, police, and regulatory actions are not stayed as long as they're intended to prove welfare, as opposed to the government acting in a capacity as a creditor for a pecuniary recovery. Commencement of HUD foreclosures is not stayed. Tax audits are not stayed, and certain family law issues related to property of the estate. And here are some of the other exceptions that are frequently seen. An act to obtain possession of non-residential property when a lease is terminated prior to the bankruptcy or during the case. One of the golden rules of leases is if it's terminated prior to bankruptcy, it can't be resurrected. But if that termination has not occurred, then the lease continues into the bankruptcy. But it has been terminated, then the landlord can continue to take possession. Although that's another area where you may want to get a comfort order. And also the creation and perfection of statutory liens for ad valorem real property taxes, and that would also include mechanics liens and purchase money security interest, certain things where you have a certain period of time within which to perfect. You can go ahead and do that without frustrating, without being limited and without violating the stay. Cash collateral and DIP financing. One of the other things that needs to be kept in mind when planning and preparing for a Chapter 11 case is cash. Most often, in almost every case we've seen, that debtor's cash is encumbered by one or more liens. Typically, there's at least a senior secured lender that has a lien on all the debtor's assets and receivables and inventory, including the proceeds, and sometimes it's even controlled through a lockbox or through a deposit control agreement with the bank, and oftentimes the bank it's the lender's bank, which gives them certain control rights. One of the things that needs to be done at the outset, and this is something that needs to be planned in advance, is to seek authority to use cash collateral, because you need to have a court order to use any cash, and this is typically a first day hearing issue, or agreement of the. And there are certain typical and customary protections that district creditors are entitled to, which are known as adequate protection. Typically includes a replacement lien, and importantly, one of the things that gets negotiated and worked out before the case and kind of the subject of focus during a case when other parties are involved is the budget. They want to have a detailed budget that identifies or that it makes projections as to what cash is coming in and is going to what expenses can be paid. Next slide. And then one of the things that needs to be assessed before filing too is cash. If they have enough cash flow to carry the case, and some of the expenditures that need to be made pre-bankruptcy are stayed. For example, a lender doesn't typically collect in the case, although they are entitled to adequate protection. Nonetheless, if an assessment needs to be made, whether use their own cash, additional money to continue to operate. If they need to borrow additional money, that's something that needs to be planned and prepared for, and it has to be teed up for because it's a post-petition loan, and there are certain typical protections that the lender is going to is the existing, because otherwise a prime, if someone's going to try to lender, it's something that but existing lender is that protected, it's not an easy showing to make. But the DIP loan comes from the existing loan. They get a super priority claim, they get a lien on assets, and a junior lien on encumbered assets.
John, I apologize for interrupting you. I think we're having a little bit of feedback on your audio. Just want to make sure we can all hear you. Maybe it might be because of your phone. Maybe if you move your phone away.
Okay, a little bit closer to the mic. So, okay, so go to the next slide. This goes over the priority scheme in bankruptcy. I won't spend a lot of time on this, but there's the general pecking order. Secured creditors come out on top. Then you have priority unsecured claims that first and foremost include administrative expenses, post-petition expenses. Most post-petition expenses are administrative, including professional fees. Then you have wages and salaries, taxes and fines, and then general unsecured creditors, and then equity. That's basically the pecking order. Next slide, Stephanie. Okay, this is one of the other benefits of bankruptcy, and that is the ability to deal with multiple claims in one form. And in order to do that, and the judge alluded to this before, the court will set a bar date, and claims need to be filed on or before that date. And as a creditor, you want to be careful to make sure you don't miss that deadline. Next slide, Stephanie. And filing claim is an important step if you're going to seek a recovery. Doesn't guarantee a recovery, but if you don't file a claim, then you're at risk of not having any recovery. This slide also highlights reclamation claims, and that is something that needs to be taken into account, because if you're a vendor that supplied goods to the debtor within 20 days of the bankruptcy, then you can get an administrative claim for the value of those goods, and it's an administrative claim that needs to be paid at the time of confirmation. There's a lot of rules and nuances to that, but that's the general overview. And then the claims allowed if there's no objection, but there's often a claims resolution process where the debtor will review the claims, object to any that it disagrees with that are unliquidated. And there's some powerful tools the Bankruptcy Code has to efficiently and effectively resolve claims in one form. And that's one of the benefits of bankruptcy, is the ability to do that. And sometimes if you're hit with litigation claims, it's another advantage to bankruptcy is to try to resolve them in this form. And particularly if it's just a claim, it's a claim that's pennies on the dollar, which gives the debtor some leverage in terms of negotiating the amount of the claim. And for unsecured creditors, they're generally not going to recover 100 cents on the dollar. Some cases may only be pennies on a dollar, which factors into the negotiations over the allowance of the claim. And in some instances, they're out of the money entirely. Next slide, Stephanie. Now we get to tax issues. Many taxes are base priority taxes under the Bankruptcy Code, and that includes basically income or gross receipt taxes that meet certain requirements that I'll discuss in the next slide. A property tax incurred before the commencement of the case, payable without penalty after 1 year before the date of the filing petition, and a tax required to be collected or withheld of which the debtor is liable in whatever capacity. And all these claims are non-dischargeable. But there is, even as the non-dischargeable claims, there is a benefit in the Bankruptcy Code because you have the ability to pay them over time. I don't know if Andrew's going to cover this later, but essentially 507A8 priority tax claims can be paid over a period of time, 5 years from the date of filing the petition. So if it takes a year to get to confirmation, you have 4 years from that point to pay out the claims over time, which could be a benefit to the debtor. So for the income or gross receipt taxes to fall under the priority claim status, it's basically those for which return is last due, including extensions, with less than 3 years before the date of the filing of the petition. So it's known as the 3-year look-back period, and needs to have been assessed within 240 days before the filing of the petition, exclusive of tolling periods. One of the things that's not here on the slide, but I did want to highlight because it is the benefit of bankruptcy, and that's Section 505 of the Bankruptcy Code, which gives the court the ability to determine, broadly speaking, any tax, as long as the tax has not been actually determined by a judicial or administrative tribunal before the commencement of the case. So if there are tax issues that the debtor has, that's something that you'll want to talk to both your tax professional and bankruptcy professional about and see, and as one factor in determining whether to file, or if you are going to file, whether that's a Section 505 is something you want to take advantage of in order to determine that tax liability. Next slide, Stephanie. Then we get to executory contracts and expired leases. The judge alluded to this before too, but when you look at the benefits of bankruptcy versus a workout, I would say that this power is probably one of the most significant benefits of the code, and that is the power that the debtor has to review and reject unfavorable or burdensome contracts or leases. So particularly this comes up in a scenario, again, if you're just trying to work out and the only thing that you really need to accomplish is work out with your secured lender, and otherwise most of your other problems are manageable, you may not need this. But if in addition to that you have an operation, you've got several leases, you've got 4 locations, you only need 2, you've got several locations that are not performing well, you need to reject those leases. This is a very important power that the debtor has, is to rid itself of burdensome contracts. And then as it pertains to leases, it's even more powerful, because upon rejection of a lease, say it's a 10-year lease has 10 years remaining, that the damages that would come from the rejection of lease are relegated to the status of unsecured claim, and they're capped as a formula, but it's generally at 1 year. So that's a pretty significant benefit and a pretty important power that a debtor in bankruptcy has. Next slide, Stephanie. Okay, I think that just covers the issues I just mentioned. So we can go to the next slide. Okay, so what's the deadline time frame for a debtor to review and object to contracts and leases? Well, for most contracts and for personal property leases, it goes until confirmation. So it can go a pretty long time. Of course, during the case, if the debtor is going to keep a contract or a lease, it generally needs to pay and perform under that post-petition, and those obligations are administrative in nature. For real property commercial leases, the debtor, and these are new deadlines that were implemented in 2005, the debtor has 120 days to assume those leases, or they're deemed rejected. And it can be extended once for up to 90 days, but that 210-day limit, that's the maximum unless you get the consent of the landlord. So this really requires a debtor with significant number of retail locations to really analyze the situation, decide what location is going to keep or reject in a relatively short time frame, shorter than it used to be under pre-2005 code law. And
copy for just 1 second and remind all the participants that if you do have a question, you can put that question into the Q&A. I did see someone raise a hand, but I'm not able to handle the question that way. It has to be through the Q&A, and we will cover all the questions. Go ahead, John, sorry.
Very certainly. Last point here is it's a pretty liberal test that favors debtors. It's a business judgment test. So if a debtor has a reasonable business judgment for wanting to reject a contract or lease, the court generally defers to the business judgment of the debtor. Next slide. So if a debtor is going to assume a lease, then needs to cure, or generally needs to cure all arrearages and other defaults, unless there is some other arrangement with the counterparty. And the debtor also needs to be able to show adequate assurance of future performance, which basically means it needs to be able to show that it's going to be able to continue to perform under lease going forward. Next slide. And if a debtor assumes that breaches, that triggers an administrative expense. So that's something, the assumption decision the debtor makes, it's one that needs to be taken seriously, because it does take away that rejection power and the ability to relegate to an unsecured claim, and they're really on the hook for it in the bankruptcy if they breach it after assumption. Next slide. As I mentioned before, if they do reject, it's a pre-petition breach, and for leases, it can be there's a cap, but those breaches are known as rejection damages. Now, what often happens in the real world is not somewhere in between. It's not necessarily an assumption or a rejection, but what happens is oftentimes the lease was negotiated 5-10 years ago. Market conditions change, and the debtor really wants to keep the location, but the rent is too high, or is no longer market rent. The debtor can use the threat of rejection to try to negotiate more favorable lease terms, and that's often what happens. That's something we're seeing now in what I would call some COVID cases, particularly where landlords don't have a line of 10 new tenants. The threat of rejection to essentially negotiate better and more favorable lease terms. So with assumption, a lot of times this happens in connection with a transaction, a sale. A lot of those in bankruptcy, but the debtor will send out a notice. All the contract counterparties, all its landlords, leases that are going to be assumed, and the cure amount, time frames by which the counterparties need to, or the landlord review and object to those cure amounts, and that's something that to be very vigilant about. Okay, next slide.
John, I think that's your last slide. Okay, wonderful job. I know it's 1:07 right now. We have a number of questions. We had planned to go to 1:15. We may go a little bit over because there's a lot that Andy still has to cover, but I want to go through some of these questions and make sure we address them before some people have to jump off. So the first question I'm going to give to Andy is from an anonymous attendee. Would a Chapter 7 discharge government-provided student loans as well, is the question. Andy, can you answer that for us?
Sure. Thank you, Stephanie. The short answer is no, unless you could prove an undue hardship. Section 523A8 is the applicable section here, and what it provides is that government student loans are not dischargeable, and they're accepted from discharge unless the debtor can file an adversary proceeding and demonstrate undue hardship. And as I understand it, there's a lot of case law about how difficult that can be. There's some discussion about judges trying to relax that some, but it's very difficult mountain to climb absent some really compelling circumstances. So that would be the short answer to the first question.
Great. Second question is from Leslie. Hi, Leslie. Is a waiver of the automatic stay and or consent to lifting the automatic stay provided in a loan agreement or a mortgage enforceable? That is a great question. Andy, can you answer that one?
I will try, and I'm interested in what the other panelists think. My initial reaction to this is that in a kind of an underlying document like a loan agreement or a mortgage, probably not. Otherwise, it would become a boilerplate term that kind of eroded the concept of the automatic stay. However, the farther you get down the line, once you get a default, perhaps you're in a forbearance agreement situation, something like that, the likelihood of it being enforceable is much higher, because at that point, that's post-default, and that's part of the agreement that's negotiated. Perhaps for the debtor, having this forbearance is in exchange for this waiver or consent, and so I think it'd be more likely in a forbearance agreement, but in a underlying mortgage or loan document. I would think the answer is no.
Judge, how do you rule?
I would say it depends. And it's probably going to depend on the judge. It's probably going to depend on the facts and circumstances of the case. There is some published case law enforcing a waiver of the stay in a forbearance agreement, and Andy's exactly right. It's not going to be enforced if it's in the originating loan documents, but if it's in a forbearance agreement where the debtor could have filed bankruptcy if the debtor wanted to, instead the debtor negotiated something with the lender. So I would say it's a strong argument if it's in a forbearance agreement, but again, it's going to be case by case and it's going to depend on the judge.
Wonderful. John, this one's going to go to you. It's an automatic stay question. It's from Nicholas. Can you please elaborate on the HUD foreclosures that are not subject to the automatic stay? For example,
Can I interrupt? Oh, I'm sorry, Stephanie. Go ahead. But when you finish, let me just interrupt before John answers.
okay. For example, which types of mortgages does this include? FHA, VA, reverse mortgages, etc. Judge?
Okay, I just want to say I've never seen this issue. 28 years of practicing law, 12 years on the bench. I've never seen this issue. So John, I hope you know the answer.
John?
Okay. I've actually never seen the issue either too, so I can't answer that level of detail. I was going to jump back on the question regarding waiver of automatic stay. I agree with the other panelists. One of the things, and it does come up in the forbearance agreement context. I think it is more likely to be enforced. It's not automatic, but it's something I do caution clients about. If they're signing a forbearance agreement, typically you will see that waiver in there. You tell them that is something that's going to have weight. It's going to have bearing. It's because the way it's perceived. Number one, courts want to encourage out-of-court workouts, and in effect, by them giving you that forbearance, you've gotten part of the benefit of what you would have obtained in the bankruptcy. And secondly, it's part of the quid pro quo. The other hand, it's not necessarily automatic. Circumstances change. There are other creditors that are being impacted, by the agreement to waive the automatic stay. That could be a factor. So, but it is something that needs to be taken seriously when entering into a forbearance agreement.
Okay, we're going to answer one more question and then let Andy cover about 15 minutes worth of the rest of the slides. And then there's some of the questions we probably won't get to, but I will commit to answering those questions in a document or an email when we send out the materials. Okay, so Ivan, your question about the differences between the assignment for the benefit of creditors and bankruptcy, that's a very long answer, and I'll be happy to answer that question for you, and I will do that in a written response to all the participants, and I'm happy to have a call with you about it as well. But that's a bear of a topic. The last question I want to cover before we let Andy go forward is Andrew's question, which is tax collection stayed or only tax audits? Any of the panelists want to take this one? Judge, you're muted.
Okay, I unmuted myself. Collection stayed. If there's an exception to the automatic stay for audits, which I think John referenced, then the audit may be stayed, but it may not be stayed, but the collection itself is stayed.
Right, perfect. Okay, so please continue to put your questions in the Q&A box, and we'll get them addressed one way or another. I know some people probably have to drop off, but I'm gonna let Andy go until 1:30 on his slides. Go
Great.
ahead, Andy.
Stephanie, I'm sitting here with my bankruptcy code. The tax audit exception to the automatic stay is 362B9, and so that will be the relevant exception to the automatic stay there. And then the HUD question is a question about the scope of 362B8 right above it. And I also haven't had experience with that, but that will be the question would be the scope of 362B8. So I will talk, I'll try to be brief. I think I've got 30 or 40 30 slides or something for 15 minutes. So Stephanie, I'm going to skip some of those. I'm just basically going to talk about a couple large concepts in the bankruptcy context and point out a couple tax issues and then conclude. The first is the slide in front of you, the disclosure statement and the plan. Those are very fundamental concepts. That's really the document that effectuates the Chapter 11 reorganization or liquidation, and the end of the bankruptcy case from the debtor's perspective, and what allows it to emerge as the confirmation of the Chapter 11 plan. And again, the plan and disclosure statement typically go together in all cases, except for the new small business cases where a disclosure statement is not required. But generally, the disclosure statement is intended to be a little more perhaps user-friendly than the plan, a little more readable. The standard in the Bankruptcy Code for whether the bankruptcy court should approve a disclosure statement is whether it contains, quote, adequate information. And then that term is defined in the Bankruptcy Code essentially to being the information that a hypothetical investor would need to make an informed judgment about the plan and decide how to vote on the plan. I would point out for all the tax folks that the definition of adequate information in the Bankruptcy Code does refer to federal tax implications of the plan being confirmed, and so that has to be in the disclosure statement in order for it to contain adequate information. A couple features of the disclosure statement I would point out that are very useful are the liquidation analysis and the projections. Those typically are in the disclosure statement. For a small business case, if you don't have a disclosure statement, those have to be in the plan. But the liquidation analysis essentially shows how creditors would do better under the Chapter 11 plan than they would under a Chapter 7 case, which is one of the kind of fundamental confirmation requirements in a Chapter 11 case. And then secondly, the projections basically are forward-looking projections of the debtor's performance and show their ability to make the plan payments. And that goes to a confirmation requirement known as feasibility. But both of those things are very important. And so that's one of the key things in a disclosure statement to take a look at right up front. Let's see. I'll go ahead and move past the disclosure. I guess one more point on the disclosure statement. Ultimately, if the disclosure statement is approved, that allows the debtor to what we call solicit the plan disclosure statement to all the creditors for voting. And you'll hear the term solicitation package. Once the disclosure statement's approved, there's a package put together that's sent to all the creditors, and that typically contains the disclosure statement, the plan, and a ballot for creditors to vote for or against the plan. In some cases, that includes opt-in or opt-outs to third-party releases. And also the solicitation package, sometimes you'll also see letters from a creditors committee voicing their support or opposition to the plan, something like that. The plan is the document that governs the debtor's reorganization or liquidation. And we could spend days talking about plans and disclosure statements and what can and can't be done in those. But very, very generally, the plan breaks all the creditors into different classes. Secured creditors are typically classified separately because they all have a separate interest in the debtor's property. And then you have priority creditors, unsecureds, equity holders, and many categories in between. And then each of the plan classifies all the creditors and then proposes a treatment for those creditors. So at a very, very high level, that's what a plan does. And so the confirmation is what allows the debtor, if it's a reorganizing plan, to emerge and become the reorganized debtor. Exclusivity, I'll touch on very, very quickly. The Bankruptcy Code provides that only the debtor can file a plan for the first 120 days of the case and has up to day 180 to seek confirmation of the plan. The debtor can seek extensions of that, and parties can seek to terminate exclusivity. And I would say about this, exclusivity can be a very significant leverage point for the debtor in negotiating with their creditors. They are the only party that has the ability to propose a plan during exclusivity and any extensions thereof. And so this can often be a very significant leverage point in a Chapter 11 case. Classification, moving to the next slide. This is just touching on what we already talked about, that the plan has to classify the creditors. The Bankruptcy Code contains some rules about what types of claims can be classified together, what types of claims cannot be. I won't get too far into the weeds on that. Voting requirements, the next slide. When the bankruptcy court is considering whether to confirm a Chapter 11 plan, the confirmation requirements are in Section 1129. Some of those relate to voting. Obviously, not all of them. A number of them have nothing to do with voting, but a few of them do depend on voting. One of those you'll see at the top of the slide here is the acceptance by each class. Each class votes as a class, and the class is deemed to accept the plan. You'll hear this a lot: 2/3 in amount, 1/2 in number of the parties that vote. The amount is the amount of the claims. So you need to have 2/3 of the amount of the claims voted in favor of the plan, and 1/2 of those that vote need to vote in favor. Then that class has accepted the plan. You need at least one impaired accepting class in a traditional Chapter 11 case, and you can sometimes cram down the remaining class as long as you have that one impaired accepting class. In a small business case, one of the changes is that a small business debtor does not need an impaired accepting class in order for the plan to be confirmed. The next slide is about the transfer tax exemption in a Chapter 11. This is a tax issue. The Bankruptcy Code, Section 1146, includes the language there that you see on the screen, that a transfer essentially of a security or a transfer of property is not subject to any law imposing a stamp tax or similar tax. And the note there is that it's only applicable after confirmation of a Chapter 11 plan. It does not apply to what's called a Section 363 sale. So to kind of zoom out, you have basically two ways to sell assets in a Chapter 11 case. One is a 363 sale that's approved by the bankruptcy court under Section 363, as the name implies, free and clear of liens, etc. That's done outside of a plan process. That is not eligible for this exemption from transfer taxes. If a plan is confirmed that contemplates a sale, that's the other way of consummating a sale, would be to confirm a plan and then have the sale close after the plan is confirmed. In that situation, that transfer is not subject to transfer taxes. I always think of doc stamps. There's a Supreme Court case on point here that I think it's Florida Department of Revenue versus Piccadilly that makes it very clear that 363 sales are not eligible to fall into this section. So discharge was kind of touched on a little bit. That's the goal of a individual debtor, at least typically in a bankruptcy case, to obtain that discharge. If we go to the next slide, the main point I want to talk about is kind of the tax issues related to the discharge. I guess one big picture point first, when you talk about a discharge, there's two code sections that relate to the discharge. One is Section 727, which is the objection to discharge, that essentially an individual debtor should not receive a discharge at all. And then Section 523, which are the exceptions to discharge, which is that the debtor can get a discharge of every debt except certain enumerated types of debt. And so you hear those two terms thrown about, whether there's an objection to discharge or a 727 challenge, means no discharge at all. It's typically for bad actors, hiding, concealing assets. And then you have Section 523, which deals with the debtor receiving a discharge, but having certain types of debts not subject to the discharge. And relevant here is the tax one, 523A1, and that generally in A1A subsumes all the claims that John talked about earlier, that 507A8 category. That's typically the 3-year look back for taxes. B is for tax debts that where return was not filed or was filed within 2 years of the petition date. And it has generated a lot of case law about what constitutes a return and whether whatever the debtor has filed triggers the time running against the IRS so that it would be dischargeable. So that's one of the frequently litigated things there. And then in subsection C, with respect to which the debtor made a fraudulent return or willfully attempted to evade or defeat such tax, another area that can be frequently litigated. Judge McHugh out of the Middle District has a very good decision on C. It's called Feshbach, and where a debtor's lifestyle was found to be so extravagant that it itself essentially constituted an attempt to willfully evade or defeat the collection of a tax. And then the bottom of the slide, 523A7, also makes non-dischargeable penalties related to taxes that are themselves dischargeable under 523A1. Next slide is on 363 sales. I'll largely skip over this. And the next slide, we talked about Section 363 sales are one of a very common way to sell assets in a bankruptcy case. The reason for that is speed. You often hear the analogy of a melting ice cube in a party coming into a bankruptcy case and taking the position that they've adequately marketed their assets prior to the bankruptcy, and that they have a stalking horse bidder typically, and they file the bankruptcy case and want to consummate that sale, typically subject to higher and better offers, and they want to do that quickly in a Section 363 sale as opposed to going through all the steps necessary for a Chapter 11 plan. And the argument is typically that the buyer wants speed and these assets have been adequately marketed, so the pool of parties interested in buying these assets have already been identified and have already conducted due diligence, and so it justifies a quick sale to the highest and best offer. So that's all I'll say about Section 363 sales. Again, we could spend hours talking about that. Single asset real estate cases. The Bankruptcy Code contains a definition of a single asset real estate debtor, and special rules apply to single asset real estate debtors. Generally, it speeds up the timeline for filing a plan and or making essentially the mortgage payments at the non-default rate. Just be aware when a debtor files, if you're a creditor, typically it is advisable to try to get a determination from the court as quickly as you can that the debtor is a single asset real estate debtor, so that all those requirements apply. The debtor is required or supposed to self-identify on the petition whether they are a single asset real estate debtor. To the extent, though, that the debtor in good faith cannot self-designate itself as a single asset real estate debtor, they will often do that because it avoids those automatic triggers of these requirements. So just something to be aware of and to monitor closely in the case.
Let me stop you there and say that in Florida, we have a number of these types of cases, single asset real estate cases. There is a significance, as you're pointing out, to them. But are there any practice pointers for dealing with single asset real estate cases from the creditor's perspective? Sure.
Yeah, from the creditor's perspective, is kind of what I touched on, that a debtor, to the extent a debtor can, in good faith, not self-identify itself as a single asset real estate debtor on the petition when they file, they typically won't, because the deadline for the payments, for example, to the lender run from the later of 90 days from the petition, if the debtor identifies itself as a single asset real estate debtor, or 30 days after the court makes a determination that the debtor is a single asset real estate debtor. And so the debtor, to the extent defensible, will typically take the position that they're not a single asset real estate debtor unless and until the creditor pushes the issue and gets that determination from the court that the rules apply. And so one of the practice pointers would be, as a creditor, if you think it applies, quickly assess that. And if the debtor hasn't admitted on the petition that these additional requirements apply to them, move for a determination from the bankruptcy court that the debtor is a single asset real estate debtor, and these restrictions apply to them, and try to get that as quickly as you can, so that the timing, these kind of constrictive timeline that's in the Bankruptcy Code for single asset real estate debtors, that applies to them.
Okay, I think we are just about out of time, but I was hoping we could skip over to slide 66, the most common tax issues in bankruptcy, and end with that, if you don't mind, Andy.
Happy to do that. Yeah, so this slide touches on what we think are the most common tax issues in bankruptcy. The first one is the discharge of indebtedness income, and that, I believe, was the subject of the first CLE in this series. There was a detailed discussion about discharge of indebtedness income, and a very good one. So I would refer everyone to that for the discharge of indebtedness income section. The priority claims, John Hutton touched on those, and that is that a lot of tax claims fall under 507A8, which makes them priority unsecured claims. They're unsecured because they don't have collateral, but they're priority, meaning they have to be paid in full prior to payment to unsecured creditors at all. And then the dischargeability of tax claims, I just briefly talked about. That's the Section 523 exception from discharge for certain types of tax claims, including all the tax claims that are priority claims under 507. And then finally, the transfer tax exemption in 11546, Section 1146. And that's the post-confirmation exemption of transfer taxes for transfers done pursuant to a confirmed plan. So that's all I have, Stephanie.
Well, Andy, I really appreciate it. I'm sorry that we cut you off on what I find to be probably the most interesting of all of the bankruptcy topics, which are the avoidance actions. But if anyone who is listening in, and we still remarkably have 91 people hanging on, if you have questions about those, please call Andy, email Andy. You'll have his contact information. I think it's most common that your client, your tax clients could come to you and say, hey, I just got this letter. It's a preference. It says there's a preferential transfer. They just paid me how much I was due. That's certainly a common thing that happens in bankruptcy, and we can talk through those issues with you. It is 1:32, and we certainly went over. We very much appreciate your time and for tuning in, right? Because we're all virtual now. There was one more question on the chat related to, I think, net operating loss carry forwards. And I will have John put together something on that and circulate it to everyone. But all of us are available if you need us to answer any questions in the future. So thank you for your time. Okay.